open up the January 5th, 2009 work session of the Board of Commissioners. And the first thing, we have our blue notebooks. The first thing we need to talk about or have presented to us is under E, under old business, regarding the Edison Square condominium project. This is while Jonathan's making his way up, or Susie, this is the consent agreement that has been presented to us in a previous meeting that no motion was made to either accept or reject. And I assume that's what you're wanting us to make a decision on, whether we will accept or reject it?
That's correct.
Or put it on the agenda again for next year. And in the past, the county attorney has provided some guidance in these cases. I don't know if you would like to hear it at this point or
Rich,
hear
why
more
don't you give us a summation of where we are in regards to consent agreements as opposed to the current status that we are under the APFO?
Well, typically on the consent agreements, what the board has chosen to do is ask staff to go back and negotiate with the developer concerning a build-out schedule so that it will push out a little further than what the developer typically originally proposes, the number of students that would be generated by the project. Typically, if the developers come back with a compromise of their original proposal in which they do push out the build-out schedule, and it's been determined what is the applicable voluntary mitigation payment, the board has typically approved those in that form. That's what's been done in virtually every other situation in the past where a consent agreement has been proposed. And in this case, the developer has compromised their original proposed build-out schedule and pushed it out, I believe, an additional year. This is one that apparently it has the actual project itself and the approvals they received from Concord has some age to it. And it wasn't actually brought over to the county until sometime after it was approved by Concord. As near as I can tell, I think from the discussion that staff has had with the developer, Shea Homes, that was through no fault of Shea. There has been some inability at times to get that information from Concord contemporaneously with their approval process. Many times find out about it after the fact. And I think Jonathan and Susie could probably speak more to that in when they get notice of it. But that's my understanding of the situation with this particular proposed consent agreement.
Is there any questions of Jonathan, Susie, or Rich?
And there's a representative from Shea Homes here also, if you have any questions for them.
Any questions for anyone from Shea?
My question is not for Shea, but it is for Jonathan. You alluded to the fact that there seemed to be a delay or a time difference between Concord approving this and our hearing about it. Explain to me a little bit about how that process goes so that we can understand a little bit better. You know, is there coordination issues there? Do we have something we need to address with the city, or what's causing that?
We had coordination issues in the past. I think we've corrected those. This particular one is actually a mixed-use development, has a commercial aspect to it also, and I think that may have been what prevented the communication originally. But again, it's a couple years old, and we have corrected those, and they now require that where they have that notification that they need to work with us on the adequate facilities as part of their approval process. So we seem to have addressed all those.
I have another question.
Sure.
On these figures of the school capacities after considering the funded improvements and so forth, in those figures, and I believe we addressed this before, and I just don't recall the answer, are we taking into account projects that we know are not being built, or, you know, and perhaps even gone bankrupt and gone to foreclosure? Are we taking into account those in these new figures, these numbers? How are we doing that?
Yeah. When you see those higher numbers, the that is taking into account all approved. When you see the future numbers of percentage capacity, that's assuming that all the other development that's approved in that area will be built on schedule. Yes, some of those projects seem to have stopped, and as their approval lapses, then we'll be able to remove them and back them out of the number. But at this point, where they have the legal right to construct those units, we continue to include those numbers. I think you'll start to see that effect coming on, but at this point, we haven't seen many of those approvals lapse yet. There was also a question, I know the chair of the school board had asked me after the last meeting about the effect of the additions being put on Boger and Fur Elementaries. Those, I don't believe, include any redistricting, so they don't show any effect on the enrollment in this particular district. That's why you don't see those improvements included.
Are there any questions? Now, this needs to be placed on old business or?
I think old business, since it's already appeared on the agenda.
Okay. We have a motion to place this under old business for a resolution for January the 20th, 2009. We have a second? All in favor say aye. Aye. All opposed? Thank you. Next matter we have is under the finance transfer of Hickory Ridge Middle School property title and authorization of agency agreement. Is this, well, excuse me, all consent agenda items. Let's flip over to G under new business. The Commerce Department rezoning case C 2008-4-R Central Area Plan implementation. It's on page 69.
I'm
Marshall.
just waiting on Ms. Morris. She's going to take the lead on this one.
I appreciate the insight that it's going to take 10 minutes to hear and resolve.
Optimists.
This case is the rezoning case for the implementation of the Central Area Plan. In your packets, you had a couple of maps as well as the staff report. That report is divided into a couple of different areas. I'm not sure how much detail you want to get into in this meeting about those areas or the specifics of the rezoning. When the case went to the Planning and Zoning Board in November, it did not receive an expedited vote. So now it will be coming to you all at the meeting on January 20th, and that will be a de novo hearing, so that will be pretty much starting from the beginning, and you will have the public hearing and take comments for and against the rezoning at that time. The staff report, you'll see, has been divided into 5 different areas. And if you'd like, I can go through those areas with you in relation to the staff report.
Please do that.
Okay. The first area is Area 1, and that is the area that is north of Highway 73. So that's this area right here. That area is roughly defined by Coldwater Creek to the west and Irish Potato to the east, and then it extends to Rowan County. The zoning designation that's being proposed for the majority of that particular area is AO, which is consistent with the land use plan and the densities called for in the land use plan. That area also has the area around Lane Street, and if you'll remember, that particular area, it calls for mixed use. We are currently not proposing for any rezonings in that particular area, just leaving it as is because it's already started to develop that way. So that area is not proposed to be changed. So it's the green area that you see, and the blue area, that area is proposed to be office and institutional, or institutional and civic.
What blue are you, what color blue?
The blue right here. That's
The Carolina,
where-
okay.
Yes, and that's because there are some institutional facilities there, so that's the more appropriate zoning designation for that area.
And when you say the zoning is institutional, is that the OI from CR to OI?
Yes.
Okay.
Yes, and the map, the larger map, it's probably hard for you to see, but that does include the zoning designations as well as this map that you should have in your packets.
Okay.
Area 2 is the area south of Highway 73 and north of 49. That particular area is still outside of the utility service boundary that was established in the agreement with the city of Concord. Again, properties in that area are proposed to be rezoned to AO in order for the densities to be consistent with the densities proposed in the densities that the land use plan calls for. So Area 1 and Area 2, both of those areas call mainly for AO zoning, which is the 1 unit per 3 acres. Area 3, which is the area south of 49 and east of the utility service boundary line, which is this area right here. That area does include some CR, which is located near the arena. It also includes AO zoning, and again, that is, those two zoning designations are proposed in order for the zoning to be consistent with what the land use plan calls for in that area. And if you'll remember, AO and CR do not permit utility extensions, public utilities. Those would all be, if somebody wanted to develop there, it would be with water and sewer on site. And that is also consistent with what the land use plan proposes.
Let me ask you this. You said that AO and CR do not permit utility extensions.
That's correct. Public utilities are not permitted in those zoning designations.
So when we're looking at the map, when I'm looking at this map with the, it says from CR to AO, okay?
Yes.
Is there any effect to the homeowner or the property owner, not homeowner, the property owner under going from a CR to an AO?
The AO permits 1 unit per 3 acres. CR permits 1 unit per 2 acres. With additional standards in the AO zoning district, folks can get up to 1 unit per 2 acres. In the CR, they can get 1 unit per 1 acre. So there would be a density difference between those two designations.
How about the use of the property other than development?
The use of the properties are relatively consistent. It's more the density for the property. If you'll remember, in our residential zoning districts, we do allow for some commercial type uses that would be neighborhood type uses, and the same types of residential uses, so it really would just be the difference in the densities permitted.
But there are some additional uses allowed or permitted in the AO as compared to the CR, additional non-residential uses, correct?
There are some, because it is an agricultural district. It has some of those uses that you would expect to support agricultural uses that are permitted in AO and may not be in CR.
Okay.
Traveling south, Area 4 is the area between 601 and 200. That particular area is proposed. Existing zoning there is CR, and that entire area is proposed to be rezoned to AO. Again, that's to accommodate the densities proposed in the plan for that area based on the input that we received at the meetings and from the citizens. The last area is Area 5, and you'll see that there are several different zoning designations proposed in that area. We are not proposing any type of a blanket rezoning for that area. That area is the area, if you remember from the land use plan, where higher densities would actually be permitted based on the land use plan. And we are only proposing that properties be rezoned where the densities are lower than what is currently permitted and what the land use plan calls for. In that particular area, there are a few properties that are proposed to be rezoned. Some of them are industrial properties where they would be rezoned to lower density industrial or light industrial. There are some properties there that would be rezoned to LDR. There's currently a project or an area that has HDR, which is the highest zoning designation. It would be down zoned to the LDR. In a couple of pieces, again, where there are institutional or civic uses, where the OI would be more appropriate. So in that particular area, we are only looking at rezoning those types of parcels. That area is also within Concord's utility service boundary. If somebody wanted to develop in that area, more than likely they would receive utilities from the city of Concord and subsequently be annexed into the city of Concord, either prior to development or as part of the development and the request for those utilities. So we did not address any upzonings in that area, because those essentially would end up being handled when they annexed into the city of Concord. And that's an overview of the different areas. In your packets, you also should have received one of the small maps that talks about the land use plan itself and what the different designations in the land use plan mean and what densities are proposed in the land use plan. So again, the rezonings that are proposed to find consistency between the land use plan and our existing zoning designations. And staff would ask that it be placed on the agenda for the 20th for a public hearing.
Okay. What's the number of meetings that we had or that were held as it relates to this?
We had multiple meetings here at the arena, a charrette. I have a list, if you give me a second, that I could look at and give you a roundabout number.
Please. If you can break it down, I'd like that. And while you're looking at that, can you explain, Rich, to the board what is going to be required or asked of us with the, when you talk about a de novo hearing, and what are we making, what decision are we supposed to make on the 20th?
Okay. The decision that's before you on the 20th is whether to rezone these 2,000-some parcels that are part of this rezoning, and to rezone them either consistent with the Central Area Land Use Plan or inconsistent with the Central Area Land Use Plan. A rezoning of this type is a legislative decision, which means that you're free in your capacity as elected members of this board to either rezone all the parcels consistent with the plan, rezone them all to some other zoning designation that's inconsistent with the plan, or some combination in between. And you don't really have to necessarily state a reason for that. It's within your legislative discretion in your capacity as commissioners. Now, having said that, you may feel somewhat limited by the interlocal agreement that this board entered into with the city of Concord with reference to the procedure to employ with reference to the adoption of the Central Area Plan and with reference to rezoning. In that interlocal agreement, the board made a commitment to work jointly with Concord to develop a plan that both boards would support, and to then rezone the affected parcels consistent with that plan. So you've made that type of contractual commitment with Concord to do that. So far, where you are in the process is you have actually worked together with Concord to hire a consultant to develop a plan, and you've actually approved that plan, which was done late last year. So the last remaining step in the process is to consider the rezonings that go along with the plan that you have approved. The question then becomes, what will Concord do if you decide to do something different from just approve rezonings consistent with the plan? Certainly, if you choose not to rezone on a mass scale consistent with the plan, in other words, if you choose not to rezone the vast majority of the parcels consistent with the plan, it would probably constitute a breach of the agreement and certainly allow Concord to pursue their contractual remedies, which among other things would be to say, well, we just have no agreement. The county's breached it, we're terminating it, we've got no deal. I don't know how legally they could enforce it to require you to rezone consistent with the plan if you chose not to do that. I think that would be something that they couldn't impose upon the county. But nevertheless, it would be inconsistent with what has been agreed to in the interlocal agreement. Now, because of this, the potential to rezone perhaps most of the parcels consistent with the plan and perhaps pull a few of them out and rezone them in a different way or not rezone them at all, I've been informed by the city that if there are just some parcels and not many, and the number hasn't been specified, but that if there is some, that you do pull a few parcels out and not rezone those consistent with the plan, that they would not consider that a breach of the agreement. They understand that in the practicalities of taking 2,000 parcels and trying to look at them in some way and then decide in advance exactly what you're going to consider about those, that there might be considerations that come up later that might affect that. So they've taken a somewhat practical view of that, but and again, they haven't indicated how many parcels that they would consider to be a small number. I think it's just been sort of left open. And for that reason, their board has not gone through with their part of the rezoning because they're looking to see what the county is going to do on this. And if the county is going to rezone consistent with the plan, at least in large measure, then my understanding is that they plan to go forward and do the same. So that having been said, the Planning and Zoning Board did consider that when they deliberated on these rezonings, and what they, I think what the consensus was among those who voted in favor of it, which was a 6-3 vote, and that's why it wasn't the supermajority. They just found that given the number of parcels and given the effort on the part of the city and the county to try to forge something that worked in that area, that they felt that it was unmanageable for them to parse through all the 2,000 parcels and try to come up with something other than just to vote in favor of approving the rezonings as proposed and then having it be considered by this board.
Any questions for Rich?
I asked Rich just a few minutes ago if it'd be okay if I participated in the discussion. As you know, I've recused myself from this, and I will recuse myself on the 20th from the vote again because I live in that area and all of the other circumstances. But there were some general questions that I wanted to ask. What is the normal process outside of what we're doing here if a person's property is rezoned and they object? Is there not already a process in place for those people to appeal that rezoning, so that if we have individual parcels within this area, they just would then proceed to that process?
The standard process for rezoning in Cabarrus County is that our planning board can make a final decision if they vote in a supermajority either to approve or deny, and that's greater than 75%, and that is the final vote. And then the appeal, if there is any, is to the Board of Commissioners. So in effect, you would act as the appeal board. So once it gets to you, any appeal from this point on would go to Superior Court.
Well, I thought your question was a little bit more specific, as if a property
All right.
owner, if we
Let's say
rezone.
Mr. Brown is not happy with his situation. What
If we
does he
adopt it
do?
as it is.
Correct.
And then a property owner wants to develop it differently or object to what we've done.
Correct.
Then they could come back with an individual petition for their property and go through that same process, going before our Planning and Zoning Commission, and then they could ultimately end up before the Board of Commissioners again.
Okay. But they do have a process that in place
They
that
do.
they can partake of, rather than just throwing the baby out with the bathwater. The second question I have is, when a property density is lowered, like from 2 houses per acre to 3 houses per acre, that does affect the ability of someone to develop that piece of property. So the property, in my opinion, would be devalued somewhat. What happens there? Is that property reevaluated in that circumstance so that the taxes on that property reflect the devaluation of that property?
This is the standard qualifier I give, and then I've had a planning board tell me to stop speaking after that point. I'm not a property appraiser. I do know in our work with them, zoning is part of what they use for their appraisal of that property, in addition with the many other factors, but it is part of that. So what is permitted under that zoning becomes part of that valuation. So I think it is possible that it could have a lower value.
That's right, and since we just went through a revaluation, we still, every year, a person still has the ability to appeal the valuation they're given. So if the zoning were changed and the property owner felt like that had an effect on the value of the property, then yes, that would be a legitimate grounds to appeal the valuation they received. And
All right,
would be reconsidered.
if the board, not, since it won't be me, if the board approves this month, that would not take effect then until next January for that individual. Is that correct? They would not have an opportunity to get a revaluation.
No, I think that they could, if you did it and it were effective in January, see, right now, their bill for this year will be based on January 1st, so it's based on the current zoning anyway, not this proposed
Okay.
zoning.
Okay.
So if you, if you approve to do it this year, then yes, they would have plenty of time to appeal it for the
Okay.
following year, which is when it would take effect for tax purposes.
Okay. Well, those were my 2 questions.
Any questions right now? Talk about a little bit about the benefits of consistent planning or zoning with the city in this area.
Would you like for me to answer your question about the meetings
Oh,
first?
yes, please.
Okay. Starting on July 18th, from February 18th, from that time until August 18th, we held 5 advisory committee meetings, 3 community meetings, which included a north and south component for 6 total community meetings here at the arena, 1 joint elected officials meeting, 2 open houses at Cabarrus County, and then also the public hearing, which was held on 8/18. In addition to that, when we had the first set of community meetings, we sent out approximately 9,000 letters to folks that lived in the area. The second time a mailing was sent out, it was also approximately 9,000. And then we also coordinated with the city of Concord for anybody that we had a phone number for. If they signed up and gave us a phone number, we did 2 different sessions where a computer actually called with a message that Amy Hawkins did, reminding them that meetings were going to be held and encouraging them to come. So we had a total of about 17 meetings, different meetings that included, opportunity for public input in different ways, whether it was the steering committee or the public hearing or the community meetings. And we also had a 3-day charrette process where the stakeholders, which was Concord, Kannapolis, Cabarrus, as well as Parks and Recs from those different jurisdictions, safety, planning, staff representatives, utilities, all of those folks participated in those charrettes. as far as having a joint plan, initially, when we talked about doing the plan together, one of the most important things was that if everybody adopted the same plan, if a citizen moved into the central area, they could have a certain expectation that if they were in that 5-year annexation area for Concord or now within the utility service boundary line, that regardless of whether they were in the city or the county, they would understand, what the density would be around them and what development was. So if they bought property with the understanding that that property would be a low density, if the property was annexed into the city, there was a possibility that maybe they could ask for smaller lots or a different type of design in order to get more lots than what is next to them. So one of the main positives that comes out of it is that you have different groups working with the same document in order to get some type of consistency with the development in that area.
Mr. Chairman, also, if I could add that plans adopted by 2 or more jurisdictions are not necessarily that unusual. That happens all the time. The difference in what was done here and what makes this, I believe, truly unique is that the 2 boards entered into a binding agreement to actually carry through these plans. That is, as far as I know, absolutely unprecedented in the state. And we've done something that apparently has just not been done before. You've given, and the city of Concord have given at least some permanency to these plans to ensure that they're actually enacted, implemented, and followed. And that's what makes this so groundbreaking in what was done, is that it's not just a plan, but it's one that you've contractually agreed to implement and enforce.
The property along 49, if we were to adopt the zoning changes as the plan calls for, does it prohibit people from developing it business-wise on 49, or, for commercial property?
Most of the area along 49, south of 49, is proposed to be CR, so it would be limited in what types of commercial uses could go there. It would be uses permitted in the CR district. The reason that zoning designation was chosen was because that particular area is outside of the utility service boundary line with Concord. And if you'll remember, utilities were not to be extended there, but it would be revisited in 5 years. So that would somewhat limit what could be developed there because utilities just are not available and are not scheduled to be available.
Now, in regards to being revisited, it can be revisited anytime during the 5 years, but it definitely gets revisited in 5 years.
Right, if that's how I understand
Okay.
the agreement, the interlocal agreement.
And, I'm sorry, if I could point out, you were asking about commercial development along 49, and commercial development was a significant portion of the conversation and discussion that was held with both the public and with the planners and the elected boards themselves. And the public that participated expressed its dissatisfaction with strict commercial development. And I think that there's not probably any or not very many planners that would think that's a good way to go about developing commercially now. And so now it's typically looked up at as being done in nodes and often with mixed uses. And that is called for in the plan specifically. And there is at least two of those, I think on 49 in this area that was considered.
If a property owner on 149 wants to put in strip, this does not prevent them from going through the application process and changing the zoning.
They could ask for the zoning to be changed, but one of the tools that staff uses in order to inform the Planning and Zoning Commission better, and for them to be better able to make their decision, is the land use plan. And the areas where the land use plan calls for mixed use are those striped areas. So in order for them to be able to recommend that a rezoning take place of that type, we would provide them with the information in the land use plan. Land use plan is a guide, it's not law, in order for them to be able to make the best decision that they can, whether or not it is appropriate for that area to be commercial. Circumstances change. 5 years from now, it may be appropriate for an area to be commercial where it currently is not appropriate for commercial type development. So they would be able to look at that and make a recommendation on whether or not it should be approved as part of a rezoning process.
Also, it is important to remember that there is a requirement when a rezoning occurs that it be accompanied by a consistency statement. That is a statement that says that this rezoning that we've just done is generally consistent with our land use plan. And while they can be creatively crafted, in some cases, it would probably require a change to the land use plan to support significant changes in zoning.
Susie, what is the special use, that one little purple area along 49 there?
That is the arena,
Oh, okay.
because it's a special use, and then there is also another special use designation, which is where the working farm is proposed to be, since that
Okay.
was in the works when we were talking about the formulation of the land use plan.
How does a landowner develop a piece of property for the, how do you deal with the consistency requirement with a landowner that is developing the property for the first time in an area? If you're the first one there, if you have the first idea to create a business or a complex, how do you do it? And we adopt this, how do you allow that person to develop his property or her property that may be inconsistent, but it is something that is needed, or it's something that's unique?
And
How do
that's
you-
where we would look at the existing zoning designation and what the intent of that zoning district is. And then we would also provide the Planning and Zoning Commission, or you all, if it was before you, the information from the land use plan and what is called for in that area. Best case scenario is that you get to go back and update your land use plans every 5 to 7 years, but sometimes that doesn't happen, and you may have an area that does change, not necessarily in that area, but what's next to that area may change, and then, change the character of that area. So we would look at all of that, and the Planning and Zoning Board would consider all of that as part of that public hearing. And if they decided that the justification for that area changing was stronger than what was currently in that land use plan, then they could give essentially some findings of facts as to why they think it should be different in support of what that property owner was proposing at that time.
Any other questions?
So just to clarify what you said, looking at the area along 49 that's very low-density residential, let's say that entire area is developed very low-density residential, that's still a lot of houses. And let's say that someone comes along with a plan along 49 for a small type of commercial, small, drop-in area type thing, hairdressers, whatever, that type of thing, a neighborhood situation. Is that the kind of thing that could be considered or would be considered, that might be considered in the future, because otherwise you're blocking that entire area for who knows how long, for any kind of commercial?
That's correct. But again, the land use plan does reflect what the citizen opinion was, and their opinion overwhelmingly was that that type of development should be considered and concentrated in those nodes and not necessarily
But you're not
along.
saying that it absolutely couldn't occur, it would have to be approved by planning and zoning?
That's correct. If it's permitted by right in that zoning district and one of those permitted uses, they could ask for that use to be permitted on that property, and then the Planning and Zoning Board would just need to consider the intent of the district as well as what the land use plan calls for, and again, as well as what's happening in that area, if there is a need for it, if they could show the need, things like that.
And if the Planning and Zoning Board does not approve it, and then that person can appeal it to the Board of Commissioners.
That's correct. That person has an appeal, but also, if there's a decision that an aggrieved property owner does not agree with, they also have the ability to appeal it to the Board of Commissioners.
Okay.
And it can be rezoned inconsistent with the plan. It's not illegal to consider a rezoning that is inconsistent with the plan.
Okay.
You do have to do the consistency statement, as John pointed out, but you can find that it is inconsistent with the plan, but nevertheless is still reasonable and in the public interest.
Commissioner Poole?
I'm not exactly certain if this is in Area 3. There's that one area that's light green that I think is the open space recreation. Is that the new property that was Parks and Rec got?
Yes.
In the Area 3, I'm looking on this sheet. This one. I can't tell exactly what that little area is. Is that open space recreation?
Yeah.
That's Green Oaks.
That's Green Oaks, okay. Is the Parks and Rec just got the land, I'm sorry, I can't remember the people's name. Thank you, Wallace's.
That's in Township 10. so
That's
that'd
down,
be
okay, I didn't know if
south
that was down here. I couldn't tell exactly from the map. It's hard to tell where all the roads are. Okay, never mind.
Right, anything that's a park on here would be designated as OI.
Okay. And do you have any knowledge of any developments that are in the planning stages currently that would have to be changed as a result of this change?
We have been
Does that
working.
make sense?
Yes, we have been working with one applicant, and they are aware of what the central area plan calls for and aware of the densities that are called for, but their particular zoning is not going to change because they're in the utility service boundary district, and that is the only project that we are currently aware of that's in the works at this time.
We had some time ago a handful of people that had some concerns about their specific property. And the last time we talked about this, those concerns were being addressed. And that was prior to the Planning and Zoning Board's vote. Have those issues and questions been addressed and been resolved?
Well, I know there are some of them in one particular instance, and this gets to some questions Commissioner Caruth had also about industrial. We have some, to be totally consistent with the plan, there are some proposals or some parcels proposed to go from a general industrial to a limited industrial, which primarily eliminates open storage areas, particularly because of the size of those parcels and because of the uses around them. Those property owners have argued that they should remain with the general industrial use, so the general industrial zoning. We have not changed that proposal because, again, we presented it to you as consistent with the plan, but that would certainly be something you would consider in your deliberations. In addition, there was a property owner I think is fairly unique in that the frontage of his property on Nisler Road is actually in the city's extraterritorial jurisdiction, so only that portion that's outside of the extraterritorial is proposed for rezoning, and it would be downzoned, and he feels like it would be even more inconsistent between the frontage and the back of his property, those two zoning districts. Again, it's consistent with the plan, but it's moved forward to you, but I don't think he feels satisfied with that and would ask that it not be rezoned also. So you may be aware of some others.
The Planning and Zoning Board did not alter any of the proposal in any way. They just adopted it blanket as how it was proposed. We've had a couple of folks out near the arena that have expressed some concerns over their property being rezoned to CR. They were looking at potentially developing the property. They had actually suggested, and I'm sure some of you saw those suggestions to LC, as well as some OI mixed in there when you initially were adopting the plan. based on that particular property. I think that probably most of the folks that came to the Planning and Zoning Commission meetings, I think they will probably express their concerns to you all at your meeting as well, as they did deal with individual properties. I think some of those folks didn't think that they could do anything with their property. Some of the discussions that we've had is that just because the property is being rezoned to AO, 1 unit per 3 acres, they still have the ability to do a minor subdivision up to that 5 lots if they wanted to create a lot for a child or another family member. So some of that has been addressed. And then we also had some folks that had concerns about subdivisions that had already been approved, but that were being downzoned as part of the process. In those cases, those subdivisions would be permitted to proceed based on their approved preliminary plat. So that would not impact them to the extent that they would not be able to do the development or anything like that. It just places a different zoning designation on the project, but they get to proceed based on what they have vested.
Okay. The general industrial to light industrial, do we have, if we were to, for the lack of a better word, grandfather them in, do we have to be specific for each one of the properties, or is it something to say those who are operating their businesses as general industrial remain general industrial?
These are primarily vacant parcels, so it'd be, if they already had a business on that parcel, then it would continue, it would already be grandfathered, no matter what
Okay.
zoning change you made. But
I thought that you said earlier that some people, the property is being, if it gets zoned from general industrial to light industrial, their concern is that they've been using it as open storage.
I was saying the primary difference between a general industrial zoning and our limited industrial zoning is open storage. So if you have a vacant parcel, then there is going to be a more limited number of uses that you could put on the property if it's limited industrial. Most of those parcels, because of the size, they already had that limitation.
They already had the LI.
They already had, they were general industrial, but they wouldn't have been able to have, the larger uses that have open storage that are only permitted in general industrial, not limited industrial, I don't think they could have gotten on those parcels anyway. So even if they keep the general industrial, some of the uses that are permitted in general but not in limited, it's not feasible to build those. We've looked at a couple of those. There was a particular business, there was a question, could they expand their particular use? It was a chemical
Americhem.
business, Americhem, that would be permitted under the limited industrial or general industrial, so it doesn't affect their expansion. Again, those other parcels are vacant, however, and there wasn't a proposed use for any of them.
Okay. Any other questions? We have a motion to place this under new business. We have a motion, we have a second. All in favor, say aye. Aye. All opposed? Next matter we have is the project ordinance for home program funds.
Good afternoon. What you have before you is a budget amendment to place the funds that we have already received by contract under the home program into a line item so that they may be expended.
Any questions? We have a motion to place this under the consent agenda. We have a motion, we have a second to place this under the consent agenda. All in favor, say aye. Aye. All opposed?
Thank you.
Next is the adequate public facilities voluntary mitigation payment adjustment for 2009.
If you remember, last year about this time, we looked at the cost of construction in relation to what our current voluntary mitigation payment is. The adequate public facilities part of our zoning ordinance does call for that amount to be adjusted January 1st of each year. And what you have in front of you is what that adjustment would be for this year. So if you look at the memo, the current amount of the voluntary mitigation payment is in that first column, and then the current amount for the voluntary mitigation payment based on the commissioner's current policy of 65% is in the next column. The overall adjusted amount for the voluntary mitigation payment for 2009 is in the third column, and that's where you see that $14,275.23. So that is the overall adjusted amount from that original amount that we adopted in the Tischler-Weiss study. The next column you'll see is the 65% of the adjusted amount for the payment, and then the last column is the proposed amount to be adopted based on the policy of 65%. The cost multiplier this year that was used was 1.064 for Charlotte, and it had a correction factor of 1.012 as listed in December of 2008. So if adopted, this would be applicable to any projects that are seeking a reservation of capacity in calendar year 2009. And staff would ask that it be added as a new business item.
Commissioner
Have a
Minot?
comment?
Yes.
I just did some quick figuring, and I don't know whether it's accurate or not, but just looking at the single-family detached APFO going from 8,600 and some to 9,200 and some, that's an 8% increase. We are in a time where housing is on the decrease. It's a very difficult time for people in the home construction business. And I think that the prudent thing for us to do this year would be to waive this increase for this year. I don't think we need to be adding to either the burden of the home builders or the burden of people trying to purchase a home, because they're going to pay for that eventually.
Couple of questions. You said you used a multiplier of 1.064%?
Yes.
Then
So
that's-
it's actually it's like 6.4%. And you multiply the number by that and then use the corrector.
Okay. Why did you use, I'm assuming the rectangle square that is the number you used,
Yes.
and that's for a fireproof steel frame. Why wasn't the wood frame used under D for 1.019?
When I met last year with our tax assessor's office, based on the classification of the schools, that is where it was determined that the rate that would be used for schools and the type of construction for the Class A fireproof steel frame.
So the number you used is actually for the school construction?
Yes.
Okay.
Yes, for that actual building, based on the discussions I had with the tax assessor's office.
Well, I certainly agree with Commissioner Minot's opinion at this point in time. I do think that we need to address it and make it a formal decision so that if we place this under new business, it can be discussed at that point in time and voted on appropriately. So do we have a motion to place this under new business? We have a second. We have a motion, we have a second. All in favor, say aye. Aye. All opposed?
Chairman, if I may add, the ordinance calls, it says that it shall be updated. So if the board so chooses, we may need to do a text amendment so that it says that it may be updated to include these new numbers, or the board could potentially make an adjustment by changing the percentage in the policy. So just something to think about.
Okay, thank you. Next is a consent agreement for Wyndham Estates subdivision project.
This is a consent agreement, so it is based on the date of submittal for preliminary plat approval prior to the new ordinance being adopted. The applicant is Wyndham Estates LLC, and the project consists of 69 single-family residential lots on approximately 80.6 acres located on Old Camden Road. The project did receive preliminary plat approval from the town of Midland on November 7th of 2007. You'll see that the amount of the voluntary mitigation payment is $4,034 per lot. And the applicant is asking that the build-out schedule be no more than 69 lots platted in 2009, so that would be the entire development. Working with the schools, you'll see that the percentages, once all of the improvements were included and we looked at seats versus those percentages and what the enrollment would be once the development was included, you'll see that they are still over 110%, so they would be required to enter into a consent agreement with the Board of Commissioners in order to proceed.
Are there any questions right now for Susie?
I've got one.
Commissioner Poole?
You referenced the capital improvement plan. If I'm not mistaken, the school board had a presentation last month for their 15-year plan. Is this based on their new plan, or is this based on the previous plan?
No,
Have you
ma'am.
gotten the new plan?
We got a draft copy of the new plan, which they said they were hoping would be adopted, I believe, this month by the board. This is actually the information that is adopted by the county CIP in that 5-year critical project list. So once the new...
So if they meet next Monday, for example, as they will meet, if they change their plan, if they approve the draft that they have out, which I think does have some changes in it, then we would meet the next week. So would you have the opportunity to update this at all? Or would it be that important to have? Does
Commissioner
that make
Poole,
sense?
the CIP that's referred to as Susie stated, is the county's capital improvement program. And that's the one that's the only one that the county can control, so it's the one that's used for this calculation. The CIP is typically only updated annually for the county, and so once the school system has modified its building program, then we typically go through a review process. It's not the case that we would necessarily adopt exactly what the school board adopted, based mostly perhaps on financial considerations. So there wouldn't be, it wouldn't come before the Board of Commissioners the next month. There would be a lot of work done prior to the actual change in the county CIP.
When would you project, not holding you to it, if presuming that next week they change their plan and that comes to us, about what timeline do you think that we would be looking at it?
Well, I wouldn't, unless it was something radically different, I wouldn't plan on doing it until you receive the new CIP with the budget.
Okay.
Typically, the most, for the county, as regards funding and raising the money for school construction, of course, the projects that you have in the 1 to 2 year horizon are those that make the largest difference, and there's typically no way of predicting what's going to exactly happen in that 3 to 5 year horizon as boards change, as economic cycles change. So we typically spend a little more time, and there's more fluidity in those latter years.
Any other questions? We have a motion to place this under new business. We have a second. We have a motion, we have a second. All in favor say aye. Aye. All opposed. Next, number 5 is the approval of the Department of Aging's policy and procedures for naming facilities and parks.
Good afternoon. What we are presenting with the Department of Aging is some consideration. Our advisory board has been considering naming the park, shelter, and walking trail behind the senior center. And in doing our research and trying to put this together, we've tried to look at the parks department's naming policies for the county, and what we have in submitting this, we realized that there are some discrepancies between the parks policies and our policies as far as the process, that it requires submittal to the Parks and Recreation or Parks Commission, a public hearing with the Parks Commission. So what we've done is adopted or presented, what we're doing is presenting a draft of policies that would parallel what Parks and Recreation has been doing with renovation or modifications that would process this through our advisory board instead of the Parks Commission. So we've been as consistent as we can with the existing policy in naming parks, but since this is a senior center park, we're recommending that the policy would be adopted to allow our advisory board to accept the recommendations to hold a public hearing at a advisory board meeting, and then to make a formal recommendation to the Board of Commissioners pending your approval for any naming of parks facility or senior center facilities or Department of Aging facilities. What we have done is modified the parks policies to comply with the process through the advisory board and the Department of Aging, but we've left the specifics about who or what would be considered for names for parks or facilities, whether it's an honorarium for someone living or memorial for someone that's deceased. Those policies are the same as they have with the Parks Department. So our plan is, if the board sees to adopt these policies, then we will come back in the future with a recommendation to name the park and the trail and the shelter behind the senior center, and then move forward through this process. But we needed to establish a process before we could do that.
Any questions for Mr. Murphy at this time?
It's
Commissioner
not a
Minnick?
question, it's just a comment. I was at the meeting where they had this discussion about wanting to get on with this naming, and it seems to me to be a very reasonable way to take something that we've already approved and used and apply it there. And I do understand that their desire to have it be the Department of Aging and the Senior Center involved, rather than just leaving it with the Parks Department. So I would favor this myself personally.
What was the discussion under General Policies number 5 and the reasoning for putting that in about only under extraordinary circumstances will the Cabarrus County Department of Aging Advisory Board to consider recommending naming anything within Cabarrus County Department of Aging system for an individual within the first 12 months following the individual's death? And how does that, was there any discussion on that in relationship to 4, which says if you're alive, you can be considered immediately?
We actually did not discuss that. We took that straight from the parks policies.
Okay.
And we decided, we did not have a problem with that, and we decided that we would be consistent with theirs, but I understand your question. I have no idea why that is there, and it wasn't an issue with our folks, so we just left it the same and was tried to be consistent with their policies.
Okay.
We had
If
no
I may make
discussion.
a comment there, just off the top of my head, it sort of makes me think that people need to have some time after
Okay.
someone's death to make a determination of
Okay.
naming something. I think immediately is more of an emotional decision.
Okay.
I will say, through this process, we've been discussing this for several years. We actually started discussing it before we built the shelter. And it's been operational for a couple of years, so it's been a process, and it was tabled, but there was some emotion in discussing who we're going to name it after, and some of our board members, there were some favorites and some folks that were near and dear to one that somebody else felt otherwise. So there's been a process involved in our discussions, and my guess is there were some sentimental kind of circumstances behind that, but we haven't dealt with that particular issue.
Any other questions? We have a motion to place this under the consent agenda. We have a motion, we have a second? We have a second. All in favor, say aye. Aye. All opposed?
Thank you.
Thank you. Under 6 is the resolution relating to the refinancing of prior installment financing contracts of various public projects and calling for a required public hearing.
We have before you tonight to place this resolution on the agenda and call for a public hearing. We have several issues. Should the refinancing of several COPS issues that we have out there, if the interest rates go into our favor towards the middle of the year, which is a possibility, we would like to have that option to be able to refinance that debt over the remainder of its life to help save some money for the county. So we wanted to go ahead and place this item on the agenda and go ahead and have the public hearing to be prepared for the circumstances in which the financing could take place. So we would be ready to take action as far as that refinancing is concerned, should the interest rates come about like we hope they do.
Any questions?
I didn't read every word. Does this say if the interest rate's lower, or is this just a blanket refinancing?
There's a
I know you
requirement.
wouldn't refinancing it up, but it seems to me you would want that in here.
There's a requirement by the local government commission. The only way they'll allow you to refinance is if there's a certain percentage of savings, and if you do not meet that criteria, they will not approve it.
Okay.
If we were to refinance, does it extend the period of years? Is it the same period of year or the balance of the years?
Same period of time.
So
just
if
lower.
if it's a 30-year note
Mhm.
and we're 15 years into it and we refinance it, we refinance for 15 years?
Correct.
Okay.
We don't extend the life of the debt.
When we refinance it, do we also have the opportunity to pay it off sooner? Because in some of the debt instruments that have been signed, you couldn't pay it off in the first 10 years, I believe. Is some of the requirements? I may be mistaken on that.
Yeah, on some of the issues that we place before you as far as the debt's concerned, there's a certain time period before you can pay it off. And this particular $60 million that we're talking about is a section of different COPS issues because those sections will qualify to be able to be prepaid.
Okay.
And they meet that criteria. When we, to refinance that, they would probably fall back under a criteria
Okay.
in which they would only have a certain time period in which they could be refunded or paid off in advance.
Okay, I have a question.
Commissioner
My only
Poole.
question was, it has on here to schedule the public hearing in February and not January?
Yes, you have to call for the public hearing and then advertise it. Okay, wait a minute.
No, that's okay. I just wanted to make sure that was correct, that we would
That might be a mistake.
call for the public hearing in January to give notice that the hearing would be held in February?
Right, because this item's going to be placed on the January 20th agenda, and once you approve this resolution, that automatically calls for the public hearing. We advertise for it and have it in February.
I just wanted
That
to
is
make sure I
correct.
understood
Sorry.
that process. No, that's okay. That's fine. I would make a motion that this be placed on the agenda.
We have a motion and a second. All in favor, say aye. Aye. All opposed? Number 7 is the resolution relating to long-term installment contract financing on various public school projects and call for a public hearing.
This is in relationship to the school projects that were placed into the CIP budget for Cabarrus County. The schools initially had to do a financing in September and one in February. And due to schedule changes, the one in September did not take place, and February is going to be delayed at least 2 more months due to some conditions that are going on. But this request is for the construction of 2 new middle schools, 2 elementary schools, 2 wing additions, and some renovations and additions to A.L. Brown High School. The majority of those projects, you have already funded the land, architect, and engineering through either COPS or cash payments. So this is the issue to bring forward, like I said, that was adopted in the CIP plan to proceed with the construction of these projects. We have $130 million in here. However, the bids have been coming under, but that is the cap not to exceed. And of course, we will only borrow what is absolutely necessary to fund those projects. But this is the first step to take place for this. The schedule is for about in May of 2009 when we'll actually sell the debt. So that'd be the ending part of the schedule for us to go ahead and start this process for those particular schools.
You said it was 2 middle schools, 2 elementary schools, and 2 renovations?
Correct.
Okay.
And then A.L. Brown renovations and
Additions rather than.
Additions.
Two
Okay.
wing
Over
additions.
and fur.
And then brown.
And then
So
Ale
it's
Brown.
three additions or renovation, 3 additions.
Yes.
Okay. Have any questions?
I move we put this on new business.
We have a motion, we have a second to place this under new business. All in favor, say aye. Aye. All opposed? Thank you. The Library Mount Pleasant Library expansion, the selection of an architect.
Well, we're asking for a couple of things here. We're asking for some direction for staff. We are constantly doing projects throughout the year, some small, some large, and we're asking for some direction as far as, is there a dollar amount or is there a size of project that the board would like for staff to narrow those firms down and bring them to you for the ultimate decision? Or are there some that are small enough and that you would feel comfortable for the staff to go ahead and make that decision?
For example, this is a 1,400 square foot addition. So in an instance like this, do you want to interview architects and make a selection, or would you be comfortable in saying if the project is X number of square feet or less, then just charge the staff with making the determination? I would prefer to do the latter. I mean, it's quicker, and when it's such a small project, I think the architects would prefer that too. But
Well, is it better to do square feet or price? Because a $1,400 square foot project could be 14,000 or 140,000 or, right?
it's unlikely that it would be quite that much. But it's up to you. I mean,
Yeah.
if of course, there are estimates on both. It's more an estimate on price than it is on size, but whichever you're comfortable with. We do, 10,000 square foot project or less is pretty small for what we do. But again, it's certainly up to whatever you feel most comfortable with.
I would be most comfortable with doing what we're doing right now. He's presenting it to us, and then at our meeting on the 20th, we can say, this project does not need our assistance. You do it. But I would not be in favor of making just a blanket policy, because then we wouldn't even know about things that maybe we should be involved with. So down the road, I can't think of one, but I just think it, just for caution, not caution, that sounds like I think you're going to be doing something you should be doing.
Right.
Just for prudence, I guess, and for the responsibility that we have. I think I'd like to know that you're doing these projects, but most of the time, if it's small, I'm fine with it.
Commissioner Privet, you have any concerns or questions, or? What we have, my thing, what I'm looking at is, I don't want it to get, it's not out of hand, and I don't want it to get out of hand at times. So that I think if we were to be aware of what projects are in the pipe, we know what they are on the CIP, but frankly, I can't tell when this expansion comes on as opposed to the Concord expansion or whatnot. I think if we're kept apprised of the situation, we can, it's easy enough to deal with that issue quicker, as opposed to, if it's a 1,400 square foot project at Mount Pleasant, that's something that, in my opinion, staff I have no problems with staff looking into, but it's good for me to know what is being looked into in case there's a question posed to me after the fact. So I agree with Commissioner Minot in this regard. At least bring it to our attention, and it's something we can address quickly, rather quickly. Since we do have the multiple meetings throughout the month.
So as far as this project here, again, it's a approximately 1,400 square foot addition to the existing Mount Pleasant Library.
And I would suggest that unless I hear something different, that it's an issue that staff can resolve in regards to the selection of the architect in the building itself.
Right. In this particular case, if you're comfortable with the staff making the selection, then you simply don't have to put it on the agenda.
Right.
And I think we can
Do
probably
we,
go, unless.
wouldn't we not need to suspend the
Well,
rules because it's a work session and make a motion to go ahead and direct staff to take care of it?
well, the other thing I just remembered is that there's a statute that requires the board to make a selection unless they've taken an action to do otherwise.
That's right.
I mean, I would think
To
that we would
designate.
need to make a motion to suspend the rules in order to address this today. I don't know exactly how that motion is
Right.
made.
I forgot about the statute that requires you to specifically designate that authority if you choose not to do it yourself as a board. So that's why I was saying if you simply didn't add it, we could move forward with a consensus. But given that there is that statutory requirement, I think you would have to delegate to me the authority to make the choice to choose the architect. You could either suspend the rules and do it now, or you can wait until the regular meeting.
Are you referring to the statute that requires that you send out the RFQs? They can waive that as well. Can we go ahead and make the selection, or on a certain level project, or do we continue?
Well, for this, I'm talking about this
solicit?
particular one.
Okay.
Where we already have solicited and have received several proposals.
Well, if we do have a motion to suspend the rules we have a motion, we have a second to suspend the rules to allow us to entertain a motion to have staff address the Mount Pleasant Library expansion. We have a motion, we have a second. All in favor, say aye. Aye. All opposed. Now, do we have a motion to allow staff to handle the library expansion at Mount Pleasant regarding to the RFQ as well as the selection of the architect?
I'll make that motion.
We have a motion, we have a second. All in favor, say aye. Aye. All opposed. Thank you. Number 9 is the adoption of an ordinance prohibiting registered sex offenders in county parks and recreation facilities in public hearing.
Good afternoon. If, in your brief summary, you will see where we have been reviewing existing sex offender ordinances of surrounding counties and cities of the people that we were familiar with that had a registered sex offender ordinance already adopted. Mecklenburg County, Hickory, Woodfin were the three when we started looking at it in July that we were aware of. Since that time, Kannapolis, Matthews, Harrisburg, Elkin, Buncombe County, the list goes on and on and on, have already adopted a very similar ordinance to what is presented here that was drawn up by Mr. Cook. There is one little sidebar, I guess. House Bill 933, which is the Jessica Lunsford Act, was enacted on December 1st of 2008, and it has the same basic principle as the registered sex offenders rules. Excuse me, but after checking with Mr. Cook and Sheriff Riley, they both felt that there were a few little loopholes, and that if we had an ordinance in addition to House Bill 933, that everything should be covered. So that's what you have before you.
Are there any questions for Mrs. Strong?
I just have a question about the wording
Okay.
in Section 2. That doesn't make sense to me. It's not the registry that we are banning, it's the individual, so,
Section 2.
yeah, under prohibition, it says no registered offender registry shall enter into or on a pond. We're not banning the registry, we're banning the individual.
That is a typo. We'll get that fixed. If I could just make a few additional comments concerning this. The proposed ordinance that you have in front of you is actually based primarily on what Mecklenburg has already enacted and one that Kannapolis enacted in September, sort of a blending of the two. This particular ordinance has been actually used as a basis for a couple of prosecutions in Mecklenburg County since it was enacted. We actually also solicited some input from the DA's office and the Sheriff's Department because they would be the ones charged with enforcing the ordinance. And this was in part based on their recommendations as well.
Any other questions or comments? We have a motion to place this under consent agenda? Excuse me, we need to have a public hearing, so this needs to be new business. We have a motion, we have a second to place this under new business. All in favor say aye. Aye. All opposed? Thank you.
Thank you.
Number 10, the solid waste budget amendment. Mr. Billifer.
Good evening. In your brief summary, you'll see that we're looking for an appropriation of a landfill's fund balance and need to address some contamination and maintenance issues at the current white goods storage area. In addition, we'll be installing some corrective measures be implemented to prevent further erosion issues that we've got going on there. We've done a considerable amount of work out there already. The fund balance, we don't see a problem with it being replenished in fiscal year 2009 with another $40,000. We're looking for a budget amendment of $15,000.
Do we have any questions for Mr. Billifer? We have a motion and second to place this on the consent agenda. All in agreement, say aye. Aye. All opposed?
Thank you.
And number 11 is a proclamation for Dr. Martin Luther King, Jr. This was a matter that was brought before us in our December meeting. Pastor Jordan asked to have the proclamation adopted in observance of Dr. King's birthday. We adopted the proclamation in 2005. We have a motion and we have a second. All in favor say aye. Aye. All opposed? Thank you. Now we have, if you'll look under our consent agenda, if there's anything different, or if you would like any questions answered under the consent agenda, we can do that right now. Otherwise, if we can have a motion to place all of the items that are tentatively listed as a consent agenda on the consent agenda. We have a motion. We have a second. We have a motion and a second. All in favor say aye. All opposed? Thank you. Motion carries. Is there any other business that we need to conduct today? Thank you all very much. That is under the
There's a request for an exception.
Watershed Improvement Commission. That is on page 147.
Although that is on the agenda anyway, so if you want to discuss it, certainly you may.
I guess my only question would be if any feedback has been received from the P&Z chair.
I saw from Mr. Berg, I think that I saw an email today saying that he did not see any objection as long as it didn't affect meetings and schedules of that make. But I think that was, let me see here. Okay.
His response is, well, I think Gene Devine is well qualified for the WIC position. I would defer comment to the county commissioner since it is their policy that would prohibit appointment to a second commission.
Thank you.
From our standpoint, from a staff standpoint, just as this is all, of course, soil and water was added another division under the Commerce Department, we see great benefit in that. In being one department, and we see also a benefit in having mutual board members, if that's possible.
Okay. Is there any questions or concerns or comments from the board?
Typically, that commission meets on a Tuesday, I think, and the P&Z meets on a Thursday, so
Okay.
there shouldn't be any issue there.
Good. So if we have nothing further, do we have a motion to adjourn?
Second motion.
We have a motion, and a second to adjourn. All in favor, say aye. All opposed.